Dred Scott decision of 1857 is perhaps the most momentous decision handed down by the Supreme Court in our history. Chief Justice Roger Taney declared in Dred Scott v. Sanford, 1857, declared officially for the court majority, 7-2, that a free Negro of the African race is not a citizen within the meaning of the Constitution of the United States. And perhaps somewhat more memorably, he declared that the authors of the Constitution that he was interpreting and defending, he believed narrowly and closely defending, the authors of the Constitution had believed that persons like Dred Scott, a slave who had stepped into free territory and many believed was therefore legally free. Justice Taney declared for the majority, and he believed for posterity and for all time that persons like Dred Scott, a free Negro of the African race, not just a slave, this would apply to slaves as well, but the interesting and more controversial and more explosive point, more partisan point for the Democrat Roger Taney was that a free Negro had no rights which the white man was bound to respect. That is a phrase that strikes us as very dramatic and very provocative in the context that we've lived in since Taney's time. It was quite widely shared, of course, in Taney's time. He also declared in this decision what was probably more immediately controversial and more immediately explosive, that the Missouri Compromise, that non-aggression pact between the emerging slave states and free states or non-slave states of 1820, that law was unconstitutional. This is only the second time in United States history that the Supreme Court had dared to declare an act of Congress duly signed into law by the President of the United States, as the Constitution specifies, unconstitutional. The first being, of course, Marbury v. Madison, an equally momentous, well, I'm saying not equally momentous. This one I think was more momentous. This decision, partly because he declared that non-aggression pact, the Missouri Compromise of 1820, to be unconstitutional, meaning that Congress had no right, had no constitutional authority to restrict or ban slavery in any of the territories that had not been organized as states at the time the Constitution was written. He argued and won the argument in 1857 that the Fifth Amendment of the Constitution actually protected the property rights of those who would carry their slave property to the territories, and the ability of Congress to legislate, to restrict slavery, or to grant jurisdiction over slavery to the states only applied to those states that had been states at the time that the original Constitution was written. That was quite partisan, quite sectional. Taney was a Democrat. Taney was a Southerner. He had been a slave owner, though he had freed his slaves, as slave owners were free to do. But this seemed to settle, or Taney hoped it would settle, the highly partisan issue of citizenship. Not for the slaves, I remind you, but for slaves who had been legally freed by the state laws. And it is important to note that many people believed, and the Constitution does seem to grant the power over things like slavery within their state borders. The Constitution does seem to concede to the states the power to declare and to protect slavery in those cases where the state government adopts slavery or carries slavery on. that the states have that power under the Constitution. Well, Taney is saying, not really, at least not in the currently controversial case, in the case that really leads to war. It's not so much, if you look at when war actually begins in the winter of 60-61, finally, if you look at that context, it's the extension of slavery to the territories that's really the provocative issue, the issue that comes to blow, more than slavery itself, because people did not believe, abolitionists like Garrison did not believe that Lincoln was one of them, did not believe that he was going to abolish slavery, but it did seem clear that the issue was going to come to a head over extending slavery into the unorganized territories. Not being citizens, Taney said, free Negroes of the African race, and that would certainly also include, he thought it was obvious, slaves as well, but even free Negroes, legally freed within the boundaries of states that have sovereignty over that issue in other respects. Even a free Negro did not have the right to sue, because only citizens have the right to sue in the courts of the United States and in the state courts organized under the Constitution. That seemed to mean war to many people. And briefly, we don't have time to go into a lot of the nuances and wrinkles, and this isn't my focus, the Dred Scott decision, but as Lincoln put it somewhat understatedly, and the war came in his second inaugural address 4 years into that war, as he found a moment of calm to contemplate the horror and destruction and bloodshed of that first modern war, modern mechanized, industrialized war, which Lincoln believed by then his side was going to win. Well, fast forward a little bit more then, that changed. Taney's declaration that a free Negro of the African race was not a citizen changed. It seemed maybe to change a little bit in the Reconstruction laws, the civil rights laws that were passed, but it changed very decisively, and it turned out permanently, as we go to press here, in the adoption of the 14th Amendment in 1868. The first line of that highly controversial, radical amendment to the Constitution was, all persons born or naturalized in the United States are citizens of the United States and of the state in which they reside. All persons born or naturalized in the United States are citizens of the United States. That was, in other words, Roger Taney is a big fat idiot. This was a highly challenging, provocative declaration, an insult to the honor of those who had given their lives in what they thought of as the old cause of defending the freedom of the South, the Confederacy. This was a very decisive, gritty thumb in the eye of those people and of the party for which they stood and were now quite militantly standing. The Democratic Party, which had been, since its birthing days in the 1820s and 30s, the party of white supremacy and the party of state rights, North as well as South, by the way. This was a very partisan amendment that managed to get adopted by the necessary number of states, ratified in 1868. And I bring all this up because what's interesting about this war over the meaning of the term citizen that is in a sense declared by the Supreme Court in 1857 and in a sense settled or attempted. Again, the authors of the 14th Amendment believed and hoped that they were settling that question in 1868. What's surprising is that it actually was pretty well settled. That question of citizenship, at least of the former slaves, who's a citizen, did not, surprisingly, in the context of 1868, let alone 1857 or 1860-61, that question over the subsequent history of the 14th Amendment did not become very controversial. That other parts of the 14th Amendment sort of hogged all the controversy and the contention and even what seemed to be warlike controversy over citizenship. The Supreme Court had declared that Roger Taney was a loser on that question, and his people, the Democratic Party, which was reconstructing itself in defiance of the other reconstruction that the Republicans were trying to impose on the South, the Democratic Party was reconstructing itself, attempting to reconstruct itself as a white man's party, declaring itself to be such in the southern states. And if African Americans, as we call them now, were to be citizens in the contemplation of the federal law, and the government, the armed forces of the United States of America, had the authority and the power to enforce that citizenship, well, the Northerners believed there would never be another war again, and they also believed that the Republicans would dominate many states in the former Confederacy because they would have majorities of voters supporting their party, the Republican Party. The Democrats were quite upset about this, not just Southern Democrats, but Democrats in the northern states as well, who depended on Southern rules and customs of considering who's a citizen and who has the right to vote, et cetera. The right was even, the insult was added to injury, or further injury to injury of 1868 when the states ratified the 15th Amendment in 1870 and expressly granted the right to vote. That turned out to be very controversial, and indeed that turned out to be a dead letter as of, depending on what state you were in 1901, 1903, early years of the 20th century, southern states, Democratic one-party states, they were becoming nullified, made the 15th Amendment a dead letter for virtually all African Americans. And in places like Virginia, for a time, they actually disfranchised the majority of the white population as well, which is an interesting wrinkle that we don't often remember. But they wanted to take the vote away from their enemies, not just their racial enemies, but the enemies that they had in their own race. And not just Republicans, but enemies in other parties like the People's Party or the Readjuster Party. That's all a story of voting and citizenship. The parts of the 14th Amendment that did become controversial turn on many issues, but the issue of other kinds of rights, the right to vote, which is a right of citizens. I'm sure you remember, many of you certainly have read about the controversies over the right to vote. They are being revived in our own time. Those are rights of citizens only. But there's another more fundamental kind of right that the 14th Amendment addresses, which was not really on Roger Taney's radar screen in that decision of 1857. Fundamental and earth-shattering as that decision was in 1857, and radical and revolutionary and provocative and insulting as that amendment of 1868 was on the issue of citizenship, Taney did not monkey in that decision over the meaning of the term person. But that term becomes contested, not always explicitly and not always as a focal point of the controversy, but the question over who's a person and what does it mean under the Constitution? What does it entail to be a person? The question of human rights, as opposed to the rights of citizens, of rights that perhaps transcend national boundaries, rights that transcend definitions of citizen, which at any given point by any state's rules and regulations, citizenship may exclude, or citizenship may be highly compromised by the status of being a convicted felon. Compromised for life in many states. Many states deny the rights of citizenship, the full rights of citizenship, but not the rights of personhood to convicted felons. In some states, as you probably know, convicted felons lose the right to vote for life in our day, not just during the time that they are paying their debt to society. That's a right of citizenship, or some say it's a privilege and immunity. or a privilege of citizenship. It's not always clear whether the right to vote is a right of citizenship. It's perhaps a privilege. And in the original Constitution and in the 14th Amendment, again, citizens have privileges and immunities, but it's very clear that human beings, persons, have rights. And those rights are, you could, if you drew a Venn diagram, the category of person is the big one, and it wholly encompasses the smaller category of citizen. And the rights of a citizen are special. The right to vote, the right, as Tawney focused on, the right to sue people in the courts of the United States and the state courts, the Republican governments of the states, Republican of the smaller governments of the states. That is something that is a right of citizens, to sue, to defend property rights and so on in the courts of law, or to attack other people's property rights in the courts of law, is something that citizens can do. You have to be a person to be a citizen. Perhaps it should go without saying, but to be a person is not enough to have the rights. It's the right to vote, the right to run, to qualify to run for office, to be an elector, a member of the Electoral College. The Constitution refers to persons, and it refers to citizens, and it's clear that all citizens are persons. It is not clear exactly what a person is. It is, by the way, quite clear from the beginning that the term person includes slaves. 3 times in the original Constitution, the Constitution uses the word person or persons to refer to people. It doesn't use the word slavery, incidentally. And it sort of puts on these long tongs. It's already a controversial issue, slavery, when the Philadelphia Convention gathers to write what became the Constitution. It's already a controversial issue, and they don't put the word slavery in the Constitution. They leave other controversial words out also, because they don't want the text of the Constitution to bubble over with controversial terms, to have a sort of odor of contention and dispute. So slavery is out because they're going to ask people to vote for it, and they don't want them to fight. They want people to find common ground. So they limit it. One of the reasons we have such a limited government, a lot of people who wrote the Constitution wanted it to be a much less limited government, a much more ambitious and, in their minds, respectable, sturdy government that could contend on the world stage with other, with empires like the British and so on, could fight them and stand proudly with them on the world stage. But they limited the government, restricted its powers, because they didn't want it to be controversial, because they wanted people to vote for it, because they were stuck with this new situation that they kind of said they were fighting for, that all men, at least, are created equal in the language of the Declaration of Independence. Was that five more to go, or was that I just passed the 5 mark? I'm done. All right. Well, one of the words they also left out of the Constitution, just to plant the seed in your minds, was the word corporation. They also thought about how controversial that was, how that was redolent of the Boston Tea Party, the real one, the one that actually happened in Boston Harbor in the 1870s, and seemed to foretell or presage the Revolutionary War and the Declaration of Independence. The Tea Party was against the British Empire, but against the leading edge and enforcer of British imperial dominion and oppression, the British East India Company, a corporation that smacked of special privileges and corruption and monarchy and all the things that the revolutionaries thought they were fighting against. And the word corporation comes to bear very much on the discussion over the meaning of the term person, the meaning of life, as much, I would say, as slavery does, although slavery kind of gets the limelight in the up to the Civil War. Certainly in the 3 decades leading up to the Civil War, contention over the term person is framed in the context and under the heat of the controversy, or over the heat of the controversy of slavery. But afterwards, during the Civil War and afterwards, this other thing, corporation becomes, corporatio, becomes an important shaper, an important source of controversy and settlement of controversy in the courts and elsewhere to define, redefine, and keep redefining the meaning of life. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.